Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. In this video, we are going to discuss the provisions of SC/ST Act which are being misused, or the Honorable Supreme Court of India opined that a pure civil case has been converted into an atrocity case for the purpose of resolving the civil dispute. Therefore, the FIR was quashed. This relates to the case of B. Venkateswaran and others versus P.Baktavatchalam in Criminal Appeal number 1555 by 2022, decided on 4th January 2023 by two judges bench, Honorable Justice M.R. Shah and Krishna Murari. Both of them, they clearly stated that this is a case having the civil dispute connections. They wanted to make it a criminal, therefore they have taken advantage of the community and alleged offence under section 3, 1, 5 and 5A of the Scheduled Caste and Scheduled Tribe Prevention of Atrocities Act 1989. Before going to the merits of the case, let us have a cursory glance towards the facts. So the appellant is arraigned as accused in the particular case. So the other side, the respondent will be the petitioner, right? So the complainant, that is the respondent in that case. So the complainant alleged that the accused, that means present petitioners, they have encroached a pathway adjacent to his house. They have encroached a common route or pathway near his house and they started to construct a temple. That means they have encroached the pathway and constructed the house, constructed the temple. And when he was he wanted to put up some construction, it was objected to by the other party, the party who was constructed the temple. He was prevented from putting up the further construction on his building, and they threatened him also. He was criminally intimidated in the name of his caste. సో ఇతని ఎలిగేషన్ ఏమిటంటే ఇతను ఇంటి ప్రక్కనే ఉన్నటువంటి ఖాళీ స్థానం లేక పాత్వేని దారిని ఆక్యుపై చేసుకుని అక్కడే గుడి కట్టారు. ఈయన తన స్థలంలో ఫర్దర్ కన్స్ట్రక్షన్ చేసుకోవాలంటే వాళ్ళు ఆపేసి బూతులు తిడతాం, క్రిమినల్ ఇంటిమిడేషన్. ఈయన పోలీస్ కేసు వేయలేదు. He has filed a private complaint under section 200 of the CRPC. So the judicial magistrate Egmore, Metropolitan Magistrate Egmore, he conducted an inquiry, he examined the witnesses, and you know the procedure, 202 CRPC. Ultimately, he issued summons to the accused persons who are arraigned under section 3 of the SC/ST Act. So when the summons were, they came, then immediately they approached the Honorable High Court of Madras. So the petitioners approached the Honorable High Court of Madras for quashment, you know, under section 482 CRPC. ఇదేమిటి అన్యాయంగా మా మీద కేసు పెడతామేంటి, మమ్మల్ని కోర్టు వారు రమ్మంటం ఏంటి, సమనింగ్ ఏంటని వెళ్తే బట్ హైకోర్ట్ ఆఫ్ మెడ్రాస్ దే డిడ్ నాట్ అగ్రీ, దే డిస్మిస్డ్ దేర్ పిటిషన్ స్టేటింగ్ దట్ ఇట్ ఇస్ SC/ST case, you have to attend, anything will be decided during the trial of the case. So agreed by the order of or dismissal of the petition by the Honorable High Court of Madras, they approached the Honorable Supreme Court of India. Of course, the advocate, he has proposed or he has stated all his arguments. Ultimately, the apex court, they have found out 3 points, important points. Number 1, there is a private case, January charge. There is a private case between the parties on the illegal construction of the so-called house on the side of the petitioner as well as the temple on the side of the accused persons. Definitely there is a civil litigation pending between them. It is a private dispute. Number 2, no allegation that the complaint is obstructed or interfered with the enjoyment of the right to property. Yes, here he says that the pathway was obstructed, the pathway is enjoyed by them, but he was not objected, he was not obstructed, and they did not interfere with the right to enjoyment of his property. ఇతని బిల్డింగ్ లోకి రాలేదు, ఇతని స్థలంలోకి రాలేదు. This is very clear. And third point, most important, the temple was in existence from since so many years. First లో ఏం చెప్పాడు, they have occupied the pathway and they started the construction of temple. But the evidence is the temple was there from so many years. Now the conclusion is that, please remember, they wanted to convert the private dispute into criminal proceedings. It is nothing but an abuse of the process of law and abuse of the court proceedings also. So here, as per section 3 within subsection 1, subsection 5, it says, if anybody wrongfully disposes any SC caste man, SC or ST caste man from his land or from his premises, or interferes with the enjoyment of his rights over the property or water, he is liable for punishment under section 3. Here they have not encroached upon his side. Even though, let us assume that they have encroached. Where they have encroached? They have engaged in the public pathway. And they have not interfered in his enjoyment of the right of property. No doubt he says that he was objected to when he started construction of the further construction. The allegation is not proved. And importantly, the temple was there in existence for so many years. So therefore, it is a very clear case of a civil dispute converted into a criminal proceedings, which should not be allowed. Therefore, the orders of the High Court as well as the FIR, they have been quashed. So this is a very good judgment by the Honorable Supreme Court of India. Sometimes you will be coming across such cases, sometimes you will be filing such cases. As advocates, you will be also be filing such advocates. Anyway, very good case law. Please read it and enrich your legal knowledge. So this case is relating to B. Venkateswaran versus P.Baktavatchalam, decided by Honorable Supreme Court of India. With this, I am concluding. Thank you very much.